Mr. Greim.
Mr. Chief Justice, and may it please the Court, the appellees should prevail here regardless of the grounds on which the Court chooses to rely. In today's America, voters like the appellees are still being racially stereotyped to place them into single-member districts. If it was ever acceptable under our colorblind Constitution to do this, it was never intended to continue indefinitely. Section 2 effects findings alone can no longer justify the widespread stereotyping of American voters based on race in violation of the 14th and 15th Amendments. It is time to reach a question this Court has never reached and hold that Section 2 alone is no compelling interest for racially gerrymandering citizens like the appellees today. The Court should affirm and direct the District Court to order a remedial map in time for the 2026 elections. I welcome any questions.
The last time we had this case, and in the materials that we have, there was quite a bit of discussion in the debate surrounding SB 8 that this district had to be drawn this way, the second district, because of the litigation earlier in the Robinson case. What's your view of the role of Robinson in the development of SB 8?
Well, it has exactly one point of contact, which is the state has admitted that it felt that it had to draw a second majority-minority district because of Robinson to avoid trial in Robinson. They did not want to have a trial during the time it was going to be scheduled, and so they passed the second majority-minority district, and they race predominated in doing that.
When you say race predominated, what exactly do you mean by that?
I just mean to apply the standard from Cooper and.
Well, I mean practically, how is it used in your mind, or in your thinking?
Well, basically the state went to the strongest remaining area of minority population, which was East Baton Rouge, and then they looked about the state for enough minority voters that was still contiguous to the main concentration in East Baton Rouge, and they went to the Northwest. And again, the goal that could not be compromised, which was the standard here, was that they had to draw a second majority-minority district, and that made race predominate, both in the direction and in the details of how the lines were drawn.
Mr. Greim, you and the Solicitor General spoke about stereotyping and how there's no place for stereotyping. But I'm wondering what stereotyping has to do with any of this. The requirements of a Section 2 vote dilution claim are essentially that there's residential segregation by race. That's not stereotyping. That's just where people live. And that there is racial block voting, essentially that whites won't vote for a black candidate. That's not stereotyping either. That's just what the data shows about racially block voting. So I'm wondering how it is that stereotyping gets into this case at all.
Well, Your Honor, two points. First of all, stereotyping is the remedy that occurs when race predominates and is used to sort voters into one district or the other. And the reason that's important is to go back to the second kind of predicate to your question. In a jingle showing, the showing that's made is not that white voters or majority voters won't vote for the minority candidate. The only showing that's currently being made is correlation. And so what we're not seeing in cases today is a showing that we can separate out partisan politics, any partisan motivations that the majority or minority voters have. And so that case could come along, but that's not part of the required showing of jingles the way courts are applying it.
Well, I think that, we've had several cases up here where we've acknowledged that there's some interaction between race and partisan affiliation. Obviously, that's right. And the task for the courts is to separate those things out, which may be hard in a given case, may be easier in a given case. But the only thing that's at issue, the violation, is where there's racially block voting. And again, it's just a there. There is currently, in order to prove a Section 2 violation, you have to show that the current conditions, not some old conditions that happened in 1962 or in 1982, but the current conditions are such that there's no equal opportunity for African American voters or some other group because there's racially block voting. And I guess I don't see where stereotyping comes into that. It's just there's a there that African Americans can't elect candidates of their choice.
Well, the problem, though, is in the remedy. The problem is that when you are drawing your remedial district, which is the very first part of Jingles, that may not be the final district you end up with, but just to reach – I'm covering your question and a question Justice Jackson asked. The very first thing the plaintiff shows is here's the community that was cracked or packed. And so to undo that, you have to look at the race of the voters all around that area, and you've got to make assumptions about them based on statistics, but you've got to make assumptions about what they think and how they vote based on their race, and you're drawing new districts based on that.
Yeah, I mean, this is the thing that we decided in Milligan, because what the state said in Milligan was that the plaintiffs could not use a map that was at all race-based themselves in order to show that there was a way out of this kind of vote dilution, these kinds of vote dilution practices. And the court said, of course you can do something that is race-based, even though not race-predominant, that we're not going to insist that you come in and ignore the factor of race when the only reason we're here is because race has played such an integral part in the voting process that people are being deprived of their voting rights because of race.
Well, Justice Kagan, the plurality in that section of Milligan drew the line between race-conscious and race-predominant districting. Race-based appears, and maybe we need to define all of our terms. It appears in the decision, but I think what is clear from that case is that the remedial maps can't allow race to predominate. I mean, the court said that the remedial map, the illustrative map, can't violate the court's redistricting decisions. And, of course, there's the entire Shaw line.
I don't think that there's any dispute as to that point, but we're a long way from racial predominance to have the plaintiffs come in with a map that in order to remedy the race-based problem that exists, the violation of voting rights based on race, itself takes race into account.
Well,
that's what Milligan said 3 years ago.
The problem,
and that wasn't a stereotype issue, and it wasn't a kind of like we're based on past conditions issue. We're based on current conditions, which is that we just proved a violation of people's voting rights based on current conditions.
Stereotyping is always the main injury in a Shaw case. It's always the injury when race predominates.
But you're asking for changes to Section 2, which is not the Shaw case. That's the confusion.
Well,
I understood that the illustrative maps that the plaintiffs bring in the beginning of a Shaw case is part of their showing that we have a problem. They're illustrative. They're not what Louisiana picked in this case. They're not what the court requires. The court gives the state, once the violation is established, the opportunity to draw its own map. So they're just showing, that's just a step that you have to do as a part of your showing that we do have this vote dilution problem in this situation. And as Justice Kagan says, that's all based on current information.
Well, but the question is, what's that is based on current information? It's not a showing of intentional discrimination.
Why does it need to be? Is your suggestion that the only thing that's worthy of remedying is the intentional discrimination by the state?
If the remedy is stereotyping and race-based,
set aside what the remedy is. I just need an answer to the initial question, right? If I'm looking only at Section 2 world, we have a mechanism for identifying race-based vote dilution and other kinds of problems. Is your view that you only are entitled to some remedy for that if you demonstrate that the state intentionally is causing this to happen to you.
Well, that's not current doctrine under Jingles, but the problem is
that your argument? Is that what you're saying we have to do?
Our argument is that if you're going to allow a race-based remedy, it must be in response to intentional discrimination.
So you don't get a remedy for an actual dilution or problem with your vote, the kinds of things that Congress cared about and that the Constitution requires. You don't get a remedy unless this was intentional on the part of the state with respect to you.
Which is a constitutional vote dilution claim which people always can be bringing.
Thank you, counsel. Justice Thomas? Justice Alito? Justice Sotomayor?
So I'm assuming that the ban on poll taxes, literacy, well, not poll taxes because those have been eliminated by the 26th Amendment, but that the literacy ban that we have will sunset too?
No, those are not those remedies don't require racial stereotyping.
Well, they do, because to prove them, you have to prove that it affects the races. I mean, I just don't understand the stereotyping concept in the Jingles factors. The Jingles factors is looking at whether these people have their vote is being diluted or if their vote is being taken away from them merely because they're black. And so if that's the case, we have always said that remedying a discrimination, you can use race. Now, you want to add the qualifier, it has to be intentional. But I don't see the 15th Amendment being limited that way. The words of the 15th Amendment are that Congress can stop any practice that dilutes voting. Practice is an act that has an effect. It didn't say intentional dilution of voting. The amendment itself talks about a practice.
Your Honor, this Court has never held that the 15th Amendment addresses anything other than intentional discrimination.
No, that's just not true. We, Justin Mulligan, and we've said in a slew of cases, Congress itself said, we're not using intent, we're using effects. And we said that's okay. That's within their power as specified in the 15th Amendment.
But Your Honor, you can only catch the effects as part of an enforcement. That's just the enforcement power at that point. So you're using the enforcement power based on a showing.
The discrimination is the practice.
The case law going back to Katzenbach and
Mr. Greim,
I'm sorry.
Oh, are we?
Yes.
Sorry.
Justice Sotomayor.
Well, I'll stop and you pick up.
Justice Kagan.
Sorry. You're all done.
No, you're not done.
I'm in no hurry.
What we've said, and this goes back umpteen years, and it was said again in Milligan, is that even if the constitutional prohibition is one on purposeful discrimination, Congress can enforce that prohibition under Section 5 of the amendment by way of prohibiting various kinds of effects. And so in Milligan we said a ban on discriminatory effects is an appropriate method of promoting the purposes of the 15th Amendment. And as I said, that goes back to Katzenbach, it goes back to City of Rome. And I understand that common ground here, including among the SG, is essentially a desire to take us back to an entirely intent-based world. But that is that is the thing that we tried to do, that Congress prevented us from doing, and that since the amendments of 1982 has been very clear that that you do an effects test for Section 2 in order to vindicate the purposes of the 15th and 14th Amendments.
It's clear what Congress did, but it was using its enforcement power only. It doesn't have the power to change what the
I'll take that. I'll take that label. That's fine.
But it was not
Congress has enforcement power under the 15th Amendment.
But it was not an appropriate use of the enforcement power, and even if it was then, it's not appropriate today because it's not congruent and proportional. And that the court has never
And
held.
what is this kind of – was it congruent and proportional in 1982, or is it just like suddenly not congruent and proportional because it's 40 years later? Like, I never understood our congruence and proportionality test, which, by the way, we have never applied to voting. But even if you were to apply it to voting, I've never understood it to have a kind of, Congress has to re-up its congruence and proportionality findings every 10 years or every 6 months or every whatever you want to say it.
Well, City of Bernie and that decision holds up Katzenbach and City of Rome as sort of paradigmatic exercises of this sort of scrutiny, although they're much older. But the point is this. Those cases were based on a strong factual record about very particular effects-based prohibitions that had just been used for purposeful discrimination. They were using poll taxes and literacy tests, although facially neutral, to purposely discriminate, and they would keep changing them over time to make sure that they kept the discrimination in place. So that was a very unique circumstance, and Congress recognized that in 1982. It said, we don't have the same kind of record that we built in 1965 under Section 4A to get rid of a literacy test in a certain area, or, when we expanded that out in 70 and 75. People were actually using literacy tests, and they were using them in a discriminatory fashion. So but none of those remedies stereotyped.
Thank you.
Justice Gorsuch? Justice Kavanaugh? Justice Jackson?
So going back to this discriminatory intent point, I guess I'm thinking of it, of the fact that remedial action absent discriminatory intent is really not a new idea in the civil rights laws. And my kind of paradigmatic example of this is something like the ADA. Congress passed the Americans with Disabilities Act against the backdrop of a world that was generally not accessible to people with disabilities. And so it was discriminatory in effect because these folks were not able to access these buildings. And it didn't matter whether the person who built the building or the person who owned the building intended for them to be exclusionary. That's irrelevant. Congress said the facilities have to be made equally open to people with disabilities if readily possible. I guess I don't understand why that's not what's happening here. The idea in Section 2 is that we are responding to current-day manifestations of past and present decisions that disadvantage minorities and make it so that they don't have equal access to the voting system, right? They're disabled. In fact, we use the word disable in Milligan. We say that's a way in which you see that these processes are not equally open. So I don't understand why it matters whether or not the state intended to do that. What Congress is saying is if it is happening, which Section 2 gives us the tools to determine, you got to fix it.
The difference is that the remedy under the ADA and other anti-discrimination laws is not stereotyping. We don't then –
It's not race-based. I take your point. But you're saying then that if the problem of no access is about race, it's just too bad because you can't have a remedy that relates to race.
Absolutely not, Your Honor. It's not whether it relates to race. It's whether the remedy that relates to race involves stereotyping voters and making assumptions about their politics and their views and their thoughts based on their race, and that's the problem. It doesn't exist in those other civil rights statutes. So why do we have to change Section 2? Okay, so fine. You say if it's the remedy problem, why aren't we just focused on whether the remedy here, the particular map in Louisiana, is predominant, using race, and if so, strict scrutiny applies, and did they narrowly tailor it? I mean, that seems to me to be the problem that you're identifying. The remedy here, you say, is overbroad. It's not using the right factors. It's using race in a stereotypical way. What does that have to do with Section 2 and changing its criteria and adding intent there? Well, Your Honor, you have to break the link between only using effects on the front end and on the back end using race and stereotyping. That's what you have to break. And so, this Court warned about that problem,
Okay, I don't see the link, but I'm out of time. Thank you.
Thank you, counsel.